everybody, and welcome to another episode of CRESI's Ontario Landlord Series. Today, I'm joined again by Rob Di Lisi from Stonegate Legal Services, and we're going to dive into the not so fun topic, but topic that we should all at least have an understanding about, as what happens when we go to the board. How does that process look? What to expect, and what outcomes should we anticipate or have to work with. So we'll start from the very beginning. Good morning. How you doing, Rob? Say hi.
Hi, Kevin. As usual, thanks for having me on here. This is going to be an interesting topic, and I'm looking forward to talking to you and your audience about it.
Yeah, no, it's I think something that people don't fully understand, even how it works to get to this point either, right? There's a lot of mis and disinformation that floats around about there. And you always say thanks for having me on, but I have to return that with thanks for being here, because your knowledge, wisdom, and experience is something that our listeners surely get something from. So thank you. So let's just start. I have a tenant who hasn't paid me rent. I've submitted my N4. We've gone our 15 days now. I now have submitted my L1 for my hearing, and I've got in the mail with my date. What happens leading up to that actual hearing? What do I have to do? And I'll let you take it from there.
Sure. So let's back up a bit, because when you do a notice for an N4, depending on the amount, the board wants to see that you try to communicate with the tenant in regards to doing a payment plan. So like you said, N4, it's a 14-day notice. 20 days if you send it by mail, with Canada Post right now on strike, but I think they resolved it. By the time that you file the L1, right now we are looking at about 3 to 4 months to get to the board. The thing is that when you get to the board, what people don't realize is that you are guaranteed a date, but you're not guaranteed to be heard. So usually there's two kinds of blocks. There's a morning block, or sorry, three kinds of blocks: morning block, an afternoon block, or an all day block. So morning block would be from 9 to about, I believe, 12 or 1 o'clock. And then the second morning block, afternoon block would be 1 to 4. And then the whole day block would be from 9 to 4 p.m. So when you get there, there's not an order where first come, first serve. You would log in with a mediator, or a host, basically, where they will register you in, and they'll give you a number and say you're block number 25. That doesn't mean that you're in 25th place. It doesn't work that way. Then what they'll do is they'll go through the uncontested, or the ones that can be resolved quicker. Now, even the ones that can be resolved quicker sometimes take time. Now, if you do get heard, and I say if just because you have to play the devil's advocate, is that the board member, or actually even before that, they will ask if you want to go into mediation. Mediation being a third party where they will hear your matter and hopefully work out a deal before you go in front of the adjudicator, or what many people will think of as the judge. Now, if you don't want to go into mediation, or mediation doesn't go your way, or the tenant doesn't agree, then you go in front of the adjudicator. The adjudicator will then hear the matter, go through the merits of the matter, and then based on that, they usually do not give you a decision right away. What will happen is that they'll say, I will reserve my decision and send it out. Now, usually to send it out, they say that they'll send it out as quickly as possible. We've seen as quickly as 30 days, even sometimes 60 days. Sometimes it even takes 6 months because of the backlog, or depending on the adjudicator. So when you go to the board, what people need to realize is that nothing is guaranteed. Even when you have a slam dunk notice where there's a non-payment of rent, the notice must be 100% correct. There cannot be any flaws or errors in the notice, and they will listen to both sides of the matter. They'll listen to the landlord and they'll listen to the tenant, because anyone can accuse anyone of not paying rent. So the tenant may say, well, the reason why I didn't pay rent was because my toilet wasn't being fixed and I had some issues, and the only way I can get the landlord's attention was to stop paying rent. Well, that now becomes something called a Section 82 issue, which is the reason why they stopped paying. Now, let's say you go a little further in the hearing and the adjudicator does allow for an eviction. The adjudicator will ask the tenant, is there any reason why I should deny or extend the eviction? And if it is, let's say, a single mother with a child and say, well, it's the winter months, it's I have a child, I need some time, this could be called Section 83 issues, where they could delay or deny the eviction. So again, Kevin, when you go to the board, it's not a slam dunk. And this is why it's always advisable to try to resolve the matter before you go to a hearing. Because anytime you go to a hearing, anything can happen. There's been times where we think it's a slam dunk and it's not a slam dunk. And then there's times where we think that we're not going to get it and we end up getting a positive result. The whole point here is that when you go to the board, you're leaving it up to a third party, which is an adjudicator, which is a tribunal, what you would call a judge, but we would call an adjudicator.
I think we've said this a few times before, but I'll say it again. That's probably one of the biggest problems here is that there's too much gray area. The fact that we don't know exactly what's going on and why something takes this or that different amount of time or different rulings for the exact same offense. Anyways, so now here we are. What if somebody doesn't show up? What if you've waited all this
Ah,
time and you're here? You are at your hearing and you got your morning block and you're sitting there, the landlord or representative representing you, and the tenant doesn't appear.
yeah. So depending on when you're heard, so let's say you're heard first. So let's say it's 9 o'clock in the morning and they're going to start. The board will say, well, Mr. Bretner, the tenant's not here. We are going to wait a half an hour to see if he does show up because they do want to give them the benefit of the doubt. They'll move on to another matter and then go back to your matter. Now, in the event that a tenant doesn't show up at all, um, it I know many people think, well, it's a slam dunk. They didn't show up. It's not always a slam dunk because what will happen is that, yes, you will get an order, but later on, the tenant can say, I didn't know about it. I wasn't informed. I didn't get the notice in the mail, whatever the case is. So, being in Canada, we always have the right to be heard. So, what will happen is that they will have another hearing and of course, the adjudicator will ask the tenant what happened, when did it happen, why did you receive it, and then they'll start a new hearing again. But remember, we're talking about 2, maybe even 3 months later. So a lot of the times it is a delay tactic, which I don't think is fair. Like if they've been notified, and a lot of times the adjudicator will ask the legal rep or the landlord, did you notify the tenant that this was going on today? And at least in my office, we email them, we mail them, we let them know that there is a hearing today. Even at the hearing, we will email them because a lot of times do get their emails and they just don't show up. So this could be used later on. But again, being the landlord and tenant board, they will allow the tenant to be heard.
I think you're right. It's a delay tactic, right? You say, hey, I'm not going to be there. Then, oh, you know what? I absolutely missed it. Sorry, life happened, or I forgot the date, or I wasn't notified, or give me a book of 12 excuses. I'm sure they'll allow all of them to be used. And now you have, again, a few more months of that same tenant probably not paying their rent, right? Where you're, another $5, $6, $7,000, whatever it may be, out of the landlord's pocket. And, again, something we've said before on other episodes, but you can steal $100 worth of gas or something like out of a store, a t-shirt, and you're a criminal. They're going to come after you for that. But thousands of dollars from a landlord to live for free, and there is no punishment, there is no ramifications, and they're just allowed.
Yeah. So I do get this question a lot, and the reason is because one is under the criminal code and one is under LTB. That's the same as when a cop comes to your door. If it's a tenant issue, they do not get involved in landlord and tenant matters. They'll tell you, we are here to simply keep the peace. If there is something that's going on with a landlord and tenant matter, you need to call the LTB. And I hear this all the time.
Yep. No, and again, I get it. It's just funny how it comes from the top, right? And it's the government that's allowing both things to be seen as separate things when technically, to me, you're still stealing from an individual, whether you
Yep.
break into their house and take their PlayStation 5 or whatever number PlayStation's at now. I think it's 5. Anyways, and or stealing thousands of dollars in rent. Mediation. So you're basically saying, let's explain this down. Both parties are going to be put in a room and they're going to be able to agree on something that is not what is actually owed, right? We'll keep the non-payment of rent just because this is the easiest one for example for everyone, I think, to grasp. Let's say my tenant has not paid me for several months. They owe me $12,000 and we're going into mediation now before our hearing.
Yep. So basically, it's a settlement, is what you're doing. And a lot of landlords don't like hearing this, but the term cash for keys, well, if you forgive what is owed, it's called a reverse cash for keys because you are forgiving what is owed to get this matter resolved. Because again, if it goes in front of the board and let's say there's one mistake, the board will more than likely dismiss the matter and you have to start all over again. One last thing I forgot to mention is that when you go on an N4 to the board, there's something called an L1, L9 application that you fill out. The L1 aspect is for the eviction. The L9 is in order to collect. So a lot of mistakes that we see that landlords make, let's say they make a mistake on the notice, but the tenant doesn't show up. The board will say, I cannot grant an eviction because there's a mistake, but I can grant an order to collect. So let's say it's $12,000. So the landlord gets excited and says, yeah, I want an order to collect. Here's what people don't realize is that now that matter's been heard, you get an order for $12,000. To collect that money, you now need to go to small claims. But you've now reset the clock on what that tenant owes because that $12,000 has already been spoken for. That means it resets back to zero. So if he owes rent, it's not 12,000 plus what he owes. It starts at what he owes. So let's say the rent is $2,000. It goes back to 2,000 because the matter for 12,000 has already been heard. Does that make sense?
Yeah, so now I have to go collect that 12,000. We've had a ruling based on that last instance, where the $12,000 he didn't fight for whenever he doesn't show up. So I again saying, okay, I want that order to collect the 12,000. I need to now go to small claims court for that. That is that problem, that situation done. Now moving forward, he doesn't pay rent again. After that month, I then have to start with an N4 for that $2,000 and start all over again to get an eviction notice because I didn't get an eviction during that first instance. I only settled for collecting what was owed.
Okay, so now think about this, Kevin. What if you get an order to collect on the 12,000, but the tenant now pays on time? You now don't have an eviction. You just have an order to collect, which more than likely you're not going to collect. So sometimes what it's better to do is actually withdraw and start all over again for the full amount. This way you get an L1, which is an eviction, and the L9 at the same time. And then once you have that, you can put it on open room. You can put it on, what's it called? Front lobby, all these other places, and then you still have the order to collect and you can do garnishment if there's anything to garnish. So that depends also if they have employment, what kind of work they do. I always make the joke that if they work at McDonald's, and nothing's wrong with McDonald's, usually this is not a career path, is that when you garnish, you're garnishing the employer, not the employee. So the court order tells the employer that you must pay the landlord and it's 20% per paycheck. But what happens if the tenant loses their job or they get fired? Well, that means you have to find out where they moved to or where they got a new job, which means you now have to hire a skip tracer, which is more money. And then you have to restart the garnishment process, which means more cost, more time, more money out of your pocket. So usually, at least for us, if the tenant is not, how do I say this nicely? If they don't have a career, let's say, like an accountant or doctor, lawyer, real estate agent, or a teacher, and they just have jobs like random jobs like landscaping or stuff like that, we know that there's probably a really slim chance of being able to collect that money.
That's sad situation there for people that are housing providers, people that are giving roofs overheads for people that need a shelter but can't afford to purchase on their own. But this is something that can happen.
So what's the solution then? So if you don't mind, I'm going to speak about it.
Yeah,
Um, Even now that it's taking a shorter time to get to the board, you are still risking waiting to go to the board, waiting for there to be an adjournment, a delay. Sometimes the adjudicator doesn't show up, technical difficulties, whatever the case is, which means, yeah, it takes 3 months to get there, but you're not guaranteed that you're going to be heard. So the solution we always tell our clients when they come with us, oh, my tenant owes rent, you should always be open to the possibility of doing some kind of settlement. You don't have to, but you should be open to it because even though it's taking a shorter time to get to the board, you still are relying on a third party to make a decision on this matter. And I don't know about you, I don't like a third party making a decision. I want to be in control. And the best way to do that is through a settlement.
we've also broken that down before, and I agree. Sometimes people only think about option A, but there is option B or C. Um, we got to think about all of them because there's pros and cons to everything, and sometimes just being able to move on quickly, turn something around, and get it back moving again is a better solution than having that delay
Right.
and being stubborn and thinking that it's going to work out.
Well,
Well,
yeah, I mean, can I just comment on that? So a lot of landlords, not that they're
yeah,
stubborn,
I
it's
used the wrong
just,
word.
yeah, it's a matter of principle. They always say to me, like, why am I going to forgive or give this tenant money and encourage them to do this again? And I always tell them because you have to step back and look at it as a business point of view that yes, you're going to give them money, but they're out in 30 days. And usually the money that you give them is less than what it would take to go to the board. On top of that, I'm not a tax accountant or a lawyer, tax lawyer, but my best friend is my accountant. And he tells me that if it's in the course of doing business, it could be tax deductible. So if it's a business, you have to treat it like a business and keep your emotions out of it. At the end of the day, this is your asset.
No, agreed. And again, I think a lot of times, in many different situations, people concentrate on the wrong number, whether they're going to spend money or whether they're going to save money. And the only number to ever think about, especially in a business situation, is what you're going to net. And we have to think about that and break down the situations. And you're right. I used the wrong word when I said stubborn, because it is, and it's principle. It's why am I having to do this? Why am I sacrificing for them being in the wrong, I guess is the way to say that.
Exactly.
It
Exactly.
Yeah, it's unfortunate.
And Kevin, I'm a landlord myself, you know this. So there's been times where I even had to do settlements on my own property. So it's like, you know, what's the expression is it's good for the goose, it's good for the gander. So everything that we do for our own properties as well. The difference is that I look at it differently because I see it so often and I know it's part of doing business. That's all it is.
Um, I'll just reference this as well. Rob and I did break this down in another episode before on Cash for Keys to looking how this settlement actually works and how the numbers kind of play out roughly and everything like that. So you can always check out that episode if you're looking for more details. You can always reach out to us or Rob as well if you wanted to chat about something. If you're having a similar situation right now with a tenant that you're trying to move on from in different ways and for different reasons, but you can always Rob and his team at Stonegate Legal Services are always here to guide, advise, and consult to make sure that you're understanding your different options and what's available to you, so you can make whatever choice is best for you in your specific situation, which is key to being a landlord, being a business owner, and um, being in business, I guess, in any way is knowing all of your options. But specifically here, being a landlord in Ontario, we're here to help guide you. Rob, do you have anything else that you want to touch on today?
I think we covered most of it that we needed to talk about today. And as always, you know, if people ever make comments on what they want to hear, I'm sure that we could do an episode on what they suggest.
I think that's a great idea. Throw some things out there. We'll talk about them. If you're having any specific situations, you can send us an email to landlord_series@cresi.ca or kevin@cresi.ca, and we'll figure those out for you, and we'll get all your questions answered. So as always, Rob, thanks so much for being here and doing this today. You're awesome.
Thank you.
And I will talk to you very, very soon.
All right. Take care.
All right. Cheers. Bye.
Please remember, while we are professionals, this podcast is for informational and entertainment purposes only. The advice shared may not apply to your unique situation. Always seek personalized advice from a qualified professional before making any investment decisions.
Hey, everybody. Thanks so much for joining us this week. I hope you enjoyed the episode. If you're finding it informative and useful, make sure to like, subscribe, share with a friend so that we can keep getting the information out there to Ontario landlords, and keep on joining us. We'll see you next time.